It's Nolan.
Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
Hey, tired of being Mr. Nice Guy to these fuck niggas. Got nothing to discuss with them unless it's about business. I replenish when they all diminish. Started caking, I ain't never finished. Can't kill him, I've been too kind. When the money pile, I need y'all to witness. Pull up on them like calisthenics with the jewels on me. Met your chick, she amused for me. Sent music to amuse, I was not enthused when they put the blues on me. Wait, fuck that, time for me to bust back. Show me where the love at, ho. Niggas on the block with the gun strap. Homie finna dump that, hit him where his mustache go. Ayy, get on my level. When it come to bank, I pimp my teller. Never been a nigga that'll rock Margiela. Never come around, I bitch, y'all better. Might not never get to rock Coachella. I don't get no fucks, I think you want better. I'm about my cheddar, don't sprinkle no feather. I skate, don't try like Bam. My cherry young nigga too hot, don't need no leather. I've been a living legend for a minute. I was at the Apache trying to sell a ticket. Nigga used to rap when Devo had the bitches. I've been learning about the boss and treat it like an auction. Labels gotta bid it. I ain't never been with Stallion. I can make a call and get the money printed. Bitch, I do not play when it come to this rapping. Studied the game when I lived in the attic. All of that struggle just made me a savage. Singing my praise on my edge, been jagged. Hating that nigga ain't fit in my jacket. I give you that shit, y'all nigga be tagging. Y'all bite my style straight trash. Y'all make it took 21 days, make stuff my habit. I'm gone.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. In this video, we're going to be getting into Megan Thee Stallion and her dispute with Milagro Cooper, aka Milagro Grrrls. All right. Now, this has been going on for about a year as well. This public dispute, this defamation lawsuit that Megan issued against Milagro, harassment, cyber stalking. Okay. She's been saying that Tory Lanez has been hiring content creators such as Milagro, the DJ that don't spin, Aiden Ross, feeding them information, paying them or leveraging relationship for information to go against Megan Thee Stallion, put out wrongful information about Megan Thee Stallion and the information surrounding the shooting of Megan Thee Stallion by Tory Lanez. And in this lawsuit, she plans to bring an end to all of it. The DJ that don't spin has been subpoenaed for deposition. Aiden Ross has been subpoenaed for deposition, right? The DJ that don't spin has already conducted an unsuccessful deposition. And I believe yesterday or the day before, he had to go back to court for a deposition in front of the judge. We'll see when that comes out and what comes out from it, if anything. Tory Lanez is also subpoenaed for another deposition because the first one was unsuccessful. He was very disrespectful to Megan's lawyer, Miss Mary Henderson, I believe it was. And they've already applied for sanctions that Tory Lanez will have to pay for wasting Megan's time, the court's time, and her legal team's time. And now that we're here, we've got Milagro Grrrls, who is now being ordered to pay sanctions, which is fees and fines, for spoliation of evidence. And it's been granted. Okay? Which means that, remember, during the discovery phase, Milagro Grrrls was ordered to submit phones and give information, logins, WhatsApp information, Discord information regarding anything and everything submitted to the courts to get to the bottom of, her conversations around Megan Thee Stallion, etc. Communications, payments accepted from Tory's father, all those things. She decided to partially submit evidence. She deleted 20,000 plus messages between herself, Tory Lanez's father, Tory Lanez's girlfriend, I guess, and others. So now the court is saying, Milagro, you too must pay. And this isn't even with the final decision. This is not a judgment in terms of the case in general. This is just for evading due process. So you can already kind of see where this is going but I ain't going to say what's going to happen because clearly jumping the gun can be detrimental. Now, since I don't have a great deal of time, this is 40 pages. I'm going to try to get through this as swiftly as possible. Some things may be skipped over due to relevance or ultra repetitive that we already know, but I'm going to do my best to get through this, okay? So this is an order from the judge granting spoliation sanctions. This cause came before the court upon plaintiff Megan Pete's request for sanctions against defendant Milagro Elizabeth Cooper for spoliation of evidence. The undersigned conducted an evidentiary hearing after hearing argument from counsel, testimony from plaintiff's expert witnesses, and having reviewed the record and being otherwise fully advised, it is hereby ordered and adjudged that plaintiff's request for sanctions for spoliation of evidence is granted. Plaintiff shall be granted an adverse interference jury instruction at trial and monetary sanctions. So they're going to have to tell the jury, that Milagro was evading discovery and evidence, which is automatically going to put her character into question. Wow, you played yourself. Factual background. This case focuses on allegations brought by Pete, a hip-hop artist known, we know that, Megan Thee Stallion, an online personality who goes by Milagro Grrrls or Mob's World, blase blah. Cooper is accused of engaging in a coordinated social harassment campaign using video, audio, and written social media posts to cause reputational and emotional distress to Pete. The allegations in the Second Amendment complaint arise from the 2022 criminal trial and conviction of Daystar Peterson, popularly known as Tory Lanez, a Canadian rapper and singer who was found guilty of assaulting plaintiff with a firearm. Found guilty. The criminal trial was widely publicized and had a large public following on social media. Pete's SAC alleges defamation per se. Count 1, promotion of an altered sexual depiction in violation of Florida Statute 836-13. Count 2, intentional infliction of emotional distress. Count 3, and cyber stalking in violation of Florida Statute 784.0845. Count 4. According to Pete, defendant operates multiple social media accounts across several platforms, including Instagram, TikTok, X.com, YouTube, and has over 100,000 followers on these social media platforms. Pete contends defendant has sole control over these accounts and, at Daystar and his affiliates' direction, uses them to harass and defame Pete by disseminating false narratives and conspiracy theories about her. The alleged falsities include claims that Pete lied under oath during the criminal trial, suffers from alcoholism, is mentally retarded, and needs a guardian. These alleged falsehoods and harassment have purportedly taken a severe toll on Pete's mental health. Pete asserts defendant made these statements with actual malice, as evidence disproving them was widely available at the time the statements were published. Okay? Now, we already know what took place with Tory Lanez's criminal trial, so I will not be going over this for review once more. But we also know that Milagro was present for that trial and still decided to give out misinformation. Okay? So here we get to the social media harassment from Milagro. According to Megan, defendant attended Daystar's criminal trial and launched a smear and harassment campaign against Pete on social media at the behest of Daystar and his affiliates. Plaintiff alleges Cooper utilized bot accounts to flood plaintiff and her supporters with hateful, derogatory, and malicious statements. Defendant has also called for violence against plaintiff. Plaintiff alleges the harassment is in retaliation for testifying against Daystar during the criminal trial. Plaintiff also alleges that Cooper promoted a deepfake pornographic video depicting an artificially created version of plaintiff engaging in sexually explicit acts. Specifically, defendant on her Bob's World account liked a post featuring the deepfake video, which archived the post into her public likes page. Defendant then directed her social media followers, as well as anyone who saw her post, to browse her then public likes page containing the video. Plaintiff alleges that this action was done to amplify the video's reach. Defendant later stated on a live stream video published to her station head account, "If y'all want to be mad at something, this is what I'll give you. Be mad that I drew attention to it." Ostensibly referring to her conduct in directing her followers to access the video. Okay? which was basically an admission that she promoted it, which ended up being subject of scrutiny from Milagro's legal team. The judge said, I will let it go because you did promote it and you said you was promoting it. Here we get into defendant's relationship with Sunstar Peterson, this Tory's dad. As it relates to the instant spoliation proceedings, plaintiff alleges that Cooper is a paid surrogate or mouthpiece for Daystar and his father, Sunstar Peterson, and conspired with them to execute this smear campaign to maliciously injure plaintiff's reputation and inflict severe emotional distress upon her in retaliation for her testimony during the criminal trial. Daystar himself is unable to speak or post directly regarding Pete due to restrictions in the underlying criminal action. A lot of people overlook that. He's not allowed to speak on her. So it's very interesting that people that are supposedly close to him continuously do. Pete alleges that defendant has a close relationship with both Daystar and Sunstar Peterson as evidenced through defendant's social media postings. Thus, communications between and relating to defendant Daystar and Sunstar are material to plaintiff's claims and are the focal point of the spoliation proceedings. Okay? On the same day the lawsuit was commenced, October 29, 2024, defendant was informed in a letter sent by email from plaintiff's counsel of her duty to preserve documents and information, related to the case as detailed in the preservation letter. Okay? So when this case was first filed, she was notified through the courts that she needed to preserve her documents and information related to the case. All the things she deleted, she was told not to. On July 11, 2025, plaintiff first informed the court of potential spoliation and a notice of issues for discovery hearing. There, plaintiff raised concerns regarding spoliation of electronically stored information from defendant's devices and social media platforms. Plaintiff requested immediate provision of defendant's login credentials to a previously agreed upon third-party forensic vendor, FTI Consulting, for collection from defendant's Discord, iMessage, WhatsApp, and Instagram accounts. Plaintiff also requested an adverse inference regarding the uncollected and spoliated communications from defendant's device. At the discovery hearing held several days later, plaintiff's counsel explained that the forensic investigation of defendant's cell phone had shown that defendant deleted text messages from her phone during specific times leading up to the filing of the complaint. Plaintiff's counsel noted specific deletions that corresponded to statements defendant made about the plaintiff from October 5th and 6th, 2022, July 29th and 30th, 2024, and August 10 through 12, 2024. Plaintiff also explained that the initial forensic investigation revealed that defendant had completely deleted WhatsApp and thus any WhatsApp messages contained on the app on her phone during the litigation. The undersigned ordered defendant to provide her phone and login credentials for WhatsApp and other apps to the neutral third-party forensic vendor, FTI, for analysis prior to defendant's then notice deposition for July 21st, 2025. The undersigned further deferred on ruling on the issue of spoliation until after defendant's deposition July 21st, so that plaintiff could seek answers during the deposition regarding the deleted evidence. Plaintiff was permitted to renew her request for spoliation sanctions after defendant's deposition. This was also memorialized in the court's order following the discovery hearing. Okay? If after defendant's deposition, plaintiff seeks to proceed on the issue of spoliation, plaintiff must promptly contact the undersigned to request an evidentiary hearing. During the hearing, the undersigned also noted that this case had fast approaching deadlines and that it was incumbent upon all parties to proceed promptly with discovery. On Tuesday, July 29th, plaintiff emailed the court renewing her request for a hearing on spoliation of evidence on August 4th, 2025. After giving the parties time to confer on availability, the court set an evidentiary hearing for spoliation proceedings for August 7th, 2025. Now, they get into the details of this hearing. The parties appeared for an evidentiary hearing on spoliation on August 7th. Plaintiff produced an expert witness from FTI Consulting, Matthias Levikov. If I messed your name up, I'm sorry. It's the butcher, nigga. And proffered testimony from defendant's July 21st, 2025 deposition. Defendant announced that their expert was unavailable to testify in person for the hearing, and defendant herself was unable to attend due to a canceled flight, which was strange within itself. Her expert couldn't be there, and she said she couldn't be there. Direct examination, Mr. Levikov testified that he works for FTI and was involved in the creation of FTI's forensic analysis report of defendant's phone. The report itself provided findings regarding deleted text messages and WhatsApp messages from defendant's phone. Mr. Levikov holds a bachelorette of computer science and has been working in the digital forensics field for 19 years, focusing on digital forensics, e-discovery, and global investigations. He explained that his colleague performed the forensic image of defendant's phone using an industry standard analysis tool called Cellbrite. From there, FTI was tasked with identifying any deletions and usage of the WhatsApp and iMessage apps on defendant's phone. Mr. Levikov confirmed that FTI worked with 2 images of defendant's phone, an initial image taken of the phone in April 2025, and a backup hard drive of the phone later provided by defendant in July 2025. FTI was able to determine deletions of text messages from defendant's phone based on missing row IDs in the phone's database. Mr. Levikov explained that when a text message is sent or received, a row ID number is automatically created within the phone's database corresponding to the message. The row ID numbers are created in sequential format based on when a message is sent or received. Further, the row ID number is permanently assigned to the corresponding message at the time the message was received or sent. And if a message is deleted, the corresponding row ID is also deleted from the database. The phone database also notes the time and the date the row ID was created, which corresponds to the time and date the message was sent or received. Therefore, it is possible to identify deleted text messages based on sequential gaps in the row ID numbers. Apparently, Ms. Milagro thought nobody would ever find out. Mr. Levikov then displayed a demonstrative Excel sheet depicting FTI's analysis of the row ID and text message gaps found from the first imaging of defendant's phone done in April 2025. The Excel sheet depicts row ID gaps from defendant's phone over the course of 6 years, with the most recent message showing as April 9th, 2025. The Excel sheet depicts the row ID number immediately preceding a gap, the row ID after the gap, and the number of missing row IDs or messages within the gap. The Excel sheet also depicts the beginning and ending timestamp corresponding to the row ID endpoints and the time elapsed within the gaps. An example of the Excel sheet data fields is below. So they give you a little taste of what they mean. Number of missing rows. What is that, 1896? It's kind of small. Exhibits Q and R were marked for identification. Exhibit Q was identified as a message extraction from defendant's phone depicting a text exchange between defendant and Sunstar, Tori's father, on December 22nd, 2022. Specifically, Exhibit Q shows Sunstar asking defendant to call him. Exhibit R depicted 3 messages sent from Daystar to defendant on December 22nd, 2022. Exhibit R depicts Daystar, that's Tori, reaching out to defendant and asking her to contact him. Mr. Levikov then directed the court to corresponding sections of the Excel sheet analysis where it showed that 36 row IDs or text messages were missing immediately after the Exhibit Q message from Sunstar on December 22nd, 2022 at 2:58 a.m. and before the messages received from Daystar in Exhibit R on December 22nd, 2022 at 5:33 a.m. So it sounds like she was instructed to delete these messages, but that's just my opinion. Moreover, there are 276 rows missing after the messages received from Daystar in Exhibit R. These 276 row IDs represent 276 missing texts spanning 13.24 hours from December 22nd, 2024 at 5:33 a.m., the time of Daystar's last message to defendant, to December 22nd, 2022, 6:47 p.m. These gaps from the Excel analysis are provided below. Plaintiff and Mr. Levikov continued this exercise with Exhibit S, which depicted a 4-message text conversation between Sunstar and defendant on October 30th, 2024, wherein Sunstar asked defendant to call him. The first message was sent by Sunstar to defendant at 3:27 p.m. on October 30th. Therefore, FTI identified a gap of 68 missing messages following this first text from 3:27 p.m. to 7:04 p.m. So within 3.5 hours, they exchanged 68 text messages that mysteriously disappeared. Wait, 2.5 or 3? Yeah. All right, yeah, 3.5. Shoot. Just making sure my math's straight. Exhibit S also contains 3 more messages between Sunstar and defendant on October 30th. At 11:15 p.m., Sunstar again asked defendant to call him. Urgency. At 11:24 p.m., defendant let Sunstar know she is on air but is about to get off, and the final reply from Sunstar at 11:25 indicates they will talk soon. FTI identified a gap of 258 missing text messages spanning 14 hours following Sunstar's last message at 11:25 p.m. on October 30th, 2024 to the 31st at 1:30 p.m. Exhibit T was also marked for identification. Exhibit T depicts another text message received by defendant from Sunstar on November 6, 2024, asking defendant to call him. Mr. Levikov testified there were 89 missing row IDs and text messages from defendant's phone following this text, ranging from November 6, 2024 at 9:30 p.m. to November 7th, 2024 at 12:52 a.m. Some interesting hours as well. Mr. Levikov also identified row ID gaps and deletions of 576 and 246 messages preceding this text, spanning from November 5th, 2024 to November 6th. It's a hell of a lot of communication. Plaintiff further noted that these deletions included those in Exhibit S happened after this lawsuit was filed and was considered an active litigation period. Ultimately, FTI was able to identify 2,337 missing row IDs and text messages in the time between Exhibit S and T, spanning October 30, 2024 to November 6, 2024. Exhibit J was thereafter marked for identification. Exhibit J is a screenshot of defendant's phone recently deleted folder depicting a deleted message thread with Sunstar containing 4 messages. The screenshot indicates that the thread will be automatically and fully deleted from defendant's phone in 30 days. Exhibit AA was marked for identification, depicting the same screenshot of defendant's recently deleted folder, but with added metadata fields. Mr. Levikov testified that the metadata shows that the screenshot of defendant's recently deleted folder was created on or around November 14th, 2024. He also later confirmed this creation date based on his own search of defendant's phone. As part of FTI's analysis, Mr. Levikov also reviewed WhatsApp usage from defendant's phone. Mr. Levikov testified that WhatsApp was not downloaded on defendant's phone during FTI's first image collection done in April 2025. So she tried to stop using standard text messaging and decided to switch up the game, switch the style up, and if they hate, and let them hate and watch the money pile up by going to WhatsApp. However, FTI was able to determine based on Wi-Fi traffic generated by the app, oh my gosh, that WhatsApp had been used on several dates preceding the collection. Indeed, a review of Exhibit M shows that WhatsApp was active on defendant's phone on 7 dates spanning from July 4th, 2023 to March 18th, 2025. Mr. Levikov reiterated that though FTI was able to see WhatsApp activity on the device. The app itself was not downloaded on her device when it was turned over to FTI in April. Therefore, it appears that WhatsApp was uninstalled before defendant's device was turned over. And Mr. Levikov testified that any messages held on the WhatsApp app are lost unless there is a backup of those chats. So they tried to get a little smarter and say, when you delete the app, everything goes. It's going to be a little bit more secure than these text messages. Exhibits X, Q, R, S, T, J, M, F, and E were therefore admitted into evidence, and the witness was tendered for cross-examination. Exhibit 8A was later admitted with restrictions during redirect examination as discussed below. During cross, Mr. Levikov confirmed that the missing row IDs represented missing text messages from defendant's phone, defendant being Milagro. Mr. Levikov admitted he could not determine who sent or received missing text messages based only on the row ID gaps, but he could confirm the phone number of the individual who had sent the messages right before and directly after. He further testified that the only way to recover the missing text messages would be from a backup containing the messages. Mr. Levikov confirmed that the row ID analysis done during direct examination was based on the first imaging of defendant's phone captured in April 2025. Mr. Levikov testified that it is possible that the row IDs depicted in FTI's analysis could have been created from multiple phones. Defendant purchased a new phone and transferred the data from her older device. However, based on his experience, when data is transferred from one phone to the other, the entire database is transferred with it. If defendant were transferring her data to a new phone, she would not be able to pick and choose specific text messages to carry over to the new phone. Mr. Levikov testified to the number of missing messages from the first analysis of defendant's phone per year from 2019 to present. So you see 2019, she deleted about 1,000 messages. 2020, she deleted 27,000. 2021, 19,000. 2022, the year of Tory Lanez conviction, she deleted 126,092 messages. Following, 91,963. 2024, last year, 70,355. And this year, she was stopped in her tracks at 7,630. But I would imagine if she was allowed, it would have gotten back near 70 to 90 to 100,000 all over again. Because what the hell? He confirmed that each missing row ID represents a missing text message, that the missing messages could be from group messages, and that he's unable to tell when the messages themselves went missing or were deleted. Rather, FTI can locate the time span of deleted messages based on the row ID before and after the gap. Mr. Levikov mentioned that errors could possibly cause row IDs to go missing, but he has not encountered that in his experience. Mr. Levikov confirmed that Exhibit AA's metadata fields were created from the first imaging of defendant's phone and that defendant did not modify the metadata of the screenshot on July 11th. He further confirmed that he had recovered the screenshot of defendant's recently deleted folder depicted in Exhibit J and that it was not modified. When asked about the WhatsApp activity found on defendant's device, Mr. Levikov testified that the dates of activity do not tell him whether messages were sent or received by WhatsApp on those dates. Rather, it shows that WhatsApp was active over Wi-Fi on those days. The parties then discussed the second imaging of the defendant's phone based on a backup hard drive that was turned over to FTI in July. Mr. Levikov testified that there were messages found on the backup hard drive that were missing from the first imaging of defendant's device in April. FTI found that there was a 13,000 message difference between the first imaging in April and the second imaging of the backup in July. However, this calculation also included new messages and sent and received after the first April 2025 imaging, including messages sent up to July 17th, 2025. So perhaps there was a backup. Maybe she tried to recover some of those texts after they had begun investigating. Plus, she was receiving new messages. Mr. Levikov confirmed FTI only captured whether WhatsApp was deleted from the device. WhatsApp had been deleted in the original April 2025 imaging, but had been re-downloaded in the subsequent July 2025 backup, now containing 6 messages. Redirect examination. Mr. Levikov presented 2 Excel sheets during redirect examination depicting FTI's analyses of missing row ID gaps from defendant's phone. The first Excel sheet, also shown during direct examination, depicted FTI's analysis of the first image of defendant's phone in April 2025. The second Excel sheet depicted FTI's continuing analysis of the second image from the backup hard drive provided in July 2025. Mr. Levikov, using row ID gap dates from previous exhibits, compared the 2 Excel sheets to see if any messages missing in the April file were recovered in the July. Mr. Levikov examined the December 22, 2022 messages in Exhibit R and found that the row ID gap 66 and 276 were identical in both the April and July files. The same exercise was repeated with one of the date ranges from Exhibit S, October 30th, 2024, from 3:27 p.m. to 5:04 p.m., showing matching row IDs in both the April and July files. Mr. Levikov then acknowledged that while he cannot pinpoint exactly when certain row IDs and text messages were deleted logically, it would have to be after the message was received or sent. For example, if row IDs and messages were missing on October 30th, 2024 between 12:01 p.m. and 12:03, the messages would have been deleted at the very least after October 30th at 12:03 p.m., the time the last available message was received or sent. During recross, defendant pointed out that in one of the examples used on redirect, there were 190 messages recovered in the July file, thus the April file and July file did not match completely for those time periods. Deposition testimony. Plaintiff presented excerpted video clips from defendant's deposition on July 21st, 2025. Mr. Levikov was briefly redirected to Exhibit 8A. He was unable to testify the last modified metadata field on Exhibit 8A as he did not access the database that produced the metadata for the exhibit. However, he was able to confirm the creation date of the screenshot in Exhibit 8A and Exhibit J as November 14th, 2024, based on his personal search of defendant's device. Therefore, the court accepted Exhibit 8A into evidence to the extent that Mr. Levikov confirmed the creation date but disregarded the last modified metadata. So here we have absence of defense expert and defendant, meaning Milagro didn't show up. She had her own expert who supposedly had conflicting information, and they didn't show up either. Lastly, the court notes that neither defendant nor her expert testified at the evidentiary hearing. While defense counsel stated that defendant's expert could have appeared via Zoom, no explicit request was made to the court prior to the hearing. Moreover, as stated during the hearing, it is unclear what more defendant's expert would be able to provide, as it is uncontested that messages had been deleted from defendant's phone and that some were deleted after litigation commenced and defendant received the preservation letter. Defendant was also unavailable due to a last-minute flight cancellation that prevented her from appearing. However, defendant was deposed 2 weeks prior to the hearing where she testified about the deletions under oath. Further, defendant's counsel was able to make factual proffers based on the deposition testimony during the hearing. At its core, spoliation is the destruction or significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. Okay? Destruction or significant alteration. In this case, deletion. Okay? It would be inappropriate to analyze the spoliation sanctions motion concerning blah, 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 using the common law in here, blah, blah. Failure to preserve electronically stored information. If electronically stored information that should have been preserved in the anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced through additional discovery, the court, 1, upon finding prejudice to another party from loss of the information, may order measures no greater than necessary to cure the prejudice, or 2, only upon finding that the party acted with the intent to deprive another party of the information's use in the litigation, may A, presume that the lost information was unfavorable to the party, B, instruct the jury that it may or must presume the information was unfavorable to the party, or C, dismiss the action or enter a default judgment. All right, we'll continue. The 11th Circuit recently analyzed the issue of spoliation of ESI under Rule 37E and summarized as follows. By its text, Rule 37E creates a two-tiered sanctions regime, with lesser sanctions under Rule 37E1 and more severe sanctions under Rule 37E2. Both parts of the rule share two preconditions. One, electronically stored information that should have been preserved in the anticipation or conduct of litigation was lost because a party failed to take reasonable steps to preserve it. And two, that information cannot be restored or replaced through additional discovery. The requirements diverge after that. Rule 37E1 sanctions are centered on the effect of a violation. They only apply where lost electronic evidence causes prejudice to another party, which then justifies sanctions no greater than necessary to cure the prejudice. Rule 37E2 sanctions, on the other hand, look more to the cause of the violation. They require a finding that the party acted with the intent to deprive another party of the information use in the litigation. If so, the court is justified in imposing more severe sanctions, adverse jury instructions, and even dismissal or default judgment. Okay? And I believe they've ruled on E2 because they are going to be informing the jury of this violation, and she's going to have to pay. Okay? What's more, Rule 37E2 sanctions do not require any further finding of prejudice. This is because the finding of intent required by the subdivision can support not only an inference that the lost information was unfavorable to the party that intentionally destroyed it, but also an inference that the opposing party was prejudiced by the loss of information that would have favored its position. Okay, we're going to skip over some of this stuff. Moreover, while the burden of establishing prejudice generally falls on the party seeking sanctions, the court notes that the plaintiff will likely never be able to prove what was contained in the destroyed messages, and that only defendant, the party who engaged in the destruction, knows how much prejudice has been potentially caused. Committee notes on Rule 37E addresses this very issue. The rule does not place a burden of proving or disproving prejudice on one party or the other. Determining the content of lost information may be a difficult task in some cases, and placing the burden of proving prejudice over on the party that did not lose the information may be unfair. In other situations, however, the content of the lost information may be fairly evident. The information may appear to be unimportant, or the abundance of preserved information may appear sufficient to meet the needs of all parties. Requiring the party seeking curative measures to prove prejudice may be reasonable in such situations. The rule leaves judges with discretion to determine how best to assess prejudice in particular cases. Therefore, where there is evidence of bad faith in the destruction of evidence, including circumstantial, it may be inferred that missing evidence was unfavorable and that there was prejudice. Okay, as an initial matter, the undersigned will only consider spoliation sanctions for deletions that occurred from when defendant received plaintiff's preservation letter on October 29, 2024 and onwards. All right, so the old text messages from 2023 and 24 will not be included. Plaintiff also seeks sanctions for messages deleted before October 29, 2024, largely premised on the theory that defendant should have reasonably anticipated litigation and known to preserve evidence based on statements made before the instant lawsuit. However, such linkage too tenuous to support spoliation sanctions. Namely, while messages were deleted before defendant's receipt of the preservation letter, it is unclear when these deletions occurred and whether they were done while defendant reasonably anticipated legal proceedings. Defendants did not reasonably anticipate litigation where there was no threat of litigation, preservation letter, or other communication, suggesting plaintiffs were contemplating litigation. While plaintiff introduced exhibits of defendant's 2022 and 2024 tweets Referring abstractly and figuratively to legal action, this is not enough for the court to infer defendant reasonably and literally anticipated the current litigation. Plaintiff's citation to Alabama Aircraft Industries, Inc. is also unconvincing as it is factually dissimilar to this case. Indeed, the spoliation dispute in Alabama Aircraft involved two companies who had previously contracted together, had instituted a document preservation plan regarding sensitive information prior to the lawsuit, and documents and statements from the defendant's officers and lawyers explicitly indicated an expectation of litigation. So although Megan wanted her text messages from 2022 and onward to be included, the judge is only staying with October 29th, 2024 and beyond, which there was still a good amount of text messages deleted even in that time frame. But unfortunately, there's probably a lot of context before then that's not being counted. Okay? Again, I'm going to try to get through this as succinctly as possible. Further, as noted during the hearing, plaintiff cannot pinpoint exactly when the deletions occurred. Rather, logic only dictates that the deletions occurred after the messages were received or sent. While this gives the court a narrowed frame of reference for deletions that occurred post-preservation letter, when defendant was on notice, it does not give the court enough evidence to impose sanctions on pre-preservation letter deletions, which could have occurred anywhere from December 11, 2019 to when defendant's phone was imaged. Therefore, the analysis is limited to deletions which occurred after the preservation letter. Rule 37E, preconditions. It contains two general preconditions. One, electronically stored information that should have been preserved in the anticipation or conduct of litigation was lost because a party failed to take reasonable steps to preserve it. And two, that information cannot be restored or replaced through additional discovery. Courts have interpreted these preconditions as requiring the movement to prove four threshold elements. 1, there must have been a duty to preserve. 2, the ESI must have been lost or destroyed. 3, the ESI must have been lost due to a failure to take reasonable steps to preserve it. And 4, the ESI must not have been restorable or recoverable through additional discovery. So they say here, defendant, as in Milagro, had a duty to preserve it. Okay, as an initial matter, defendant undoubtedly had a duty to preserve ESI related to this action the moment she received plaintiff's preservation letter. As elicited during defendant's deposition, defendant received the preservation letter on October 29, 2024, indicating plaintiff's intent to sue and instructions to retain a number of documents and information, including any and all communications with or regarding Daystar Peterson and any and all communications with or regarding Sunstar Peterson. Defendant acknowledged she received the preservation letter on October 29th and understood that she was not to delete information related to the topics therein. Therefore, from October 29th, 2024, defendant was on notice of litigation and had a duty to preserve documents and information related to the case as detailed on the preservation letter. B, ESI was lost or destroyed. Next, as noted during the hearing, it is not disputed that messages were erased or deleted from defendant's phone after she received the preservation letter. Indeed, plaintiff's expert testified at length regarding missing row IDs from defendant's phone corresponding to thousands of missing messages from the device after litigation. A number of these deleted text messages ostensibly related to this case and to the topics ordered to be retained in the preservation letter. For example, the screenshots found in defendant's recently deleted messages folder show deleted messages from Sunstar Peterson, which she was ordered to retain. Plaintiff's expert testified that the screenshot was created on or around November 14, 2024, following defendant's receipt of the preservation letter. When asked about Exhibit J during her deposition, defendant was unable to provide a reason why the messages from Sunstar appear in the recently deleted folder. While defendant testified that she often goes on a trip in November and sometimes deletes messages to make space in her phone for the trip, she stopped just short of stating that Sunstar's messages were deleted for such reason. They begin to quote her deposition. Question says, I think you are about to tell me that maybe you were creating space for your show. She says, I wouldn't say for certain. You just asked me what was kind of going on around that time. I don't know why. When asked whether she remembered deleting text from Sunstar, she simply stated no. And while she stated she never thought to purposefully delete messages from Sunstar. Objective evidence of the deleted messages with no viable explanation from defendant gives the court reason to doubt the credibility of that statement. Indeed, though defendant testified during her deposition that she stopped communicating with Sunstar following the commencement of the instant lawsuit, her phone records show differently. You done fucked up. Finding defendant's testimony regarding missing text messages unreliable where evidence showed selective preservation of messages by defendant. The deletions shown in Exhibit J and AA are enough to warrant spoliation sanctions in and of themselves. Moreover, the temporal proximity of certain deletions to discovered communications between defendant and Sunstar gives reason for the court to believe that the deleted messages were related to this case. Let's continue. Exhibit S and T are prime examples of this. Exhibit S depicts 4 messages between defendant and Sunstar on October 30th, 2024, wherein Sunstar asked defendant to call him twice. Remember, she was issued the preservation letter the day before. FTI was able to identify gaps of 65 missing messages and 258 missing messages immediately following each of his requests. Similarly, Exhibit T shows a message from Sunstar on November 6, 2024, again asking defendant to call him. FTI identified a gap of 89 missing messages immediately following his text. Plaintiff's expert also identified missing gaps of 576 and 246 messages preceding the Exhibit T text from November 5th to November 6th. So each time he calls or texts and says, call me, they get on the phone, they start exchanging text messages, and then she deletes them. Thus, based on the timing of the deletions occurring immediately after or around the time defendant received messages from Sunstar, the court can infer that at least some of these messages would have been relevant to the case. Lastly, as testified by plaintiff's expert and found in FTI's report, WhatsApp was active on defendant's phone on several dates from 2023 to 2025, but was deleted from the device when FTI conducted its first imaging on April 2025. Specifically, WhatsApp was active on 2 post-preservation letter dates, March 11, 2025 and March 18th. While WhatsApp appeared in the later backup of defendant's device turned over in July, containing 6 messages, these messages did not match the March 2025 usage dates and were sent or received after the first imaging. Any messages sent or received by defendant on WhatsApp on March 11th and 18th are likely lost unless a backup is found. Further, defendant testified during her deposition that she had used WhatsApp to talk to Sunstar when he was out of town, but subsequently deleted the app. Defendant acknowledged that she regularly deletes the app and did not dispute that she had used WhatsApp between July 2023 and March 2025 to speak with Sunstar. As such, the court may infer ESI was lost that related to this case and likely involved topics the defendant was explicitly ordered to preserve. It's a hell of a lot of communication, man. I'm gonna lie. The ESI was lost due to defendant's failure to take reasonable steps to preserve it. As to the third requirement, it is largely uncontested that defendant failed to take reasonable steps to preserve the ESI. As noted above, defendant admitted to deleting text messages and WhatsApp during her deposition. Moreover, defendant, when showed the FTI report showcasing thousands of deleted messages from 2019 to 2025, admitted she had no reason to doubt the accuracy of the report and the deletions. Defendant testified that she often deletes messages from her phone to make more room for storage. While defendant testified that she did not delete messages related to plaintiff or this case, she also testified that she did not know why the texts from Sunstar were deleted and had no clear explanation for the thousands of deleted messages following the receipt of the preservation letter. So she said she didn't delete them, but she can't explain why they was gone. Come on. Moreover, when asked whether she preserved messages relevant to this case, defendant stated that she tried her best to keep the messages she felt like were important. This is not good enough. The ones you felt were good, were important. What? Defendant was on notice to her duty to preserve all evidence related to this case, not just what she felt was relevant. She was specifically told to retain all communications with and related to Daystar and Sunstar. She failed to take reasonable steps to do so. The ESI is not restorable or recoverable through additional discovery. Lastly, the missing text messages are likely not restorable or recoverable through additional practicable discovery. As testified to by plaintiff's expert, the deleted messages are lost unless a backup is found. While defendant provided the July file backup, which restored around 13,000 messages missing from the initial device image, relevant text messages are still missing. Further, while plaintiff has attempted to recover the deleted messages from defendant and various providers, the continued search for thousands of messages does not appear to be an efficient expenditure of resources with trial deadlines looming, nor is it practicable, as it is unclear who some third-party recipients are and whether they would have preserved the messages. Defendant did not object to this element during the hearing, nor did she argue for a continued search of the ESI. 2. Bad faith. Next, because plaintiff seeks an adverse inference under Rule 37E2, the court must consider whether defendant acted with the intent to deprive the plaintiff of the ESI. The intent to deprive standard is equivalent to bad faith, which can be established through direct or circumstantial evidence. In the absence of direct evidence of bad faith, the court will consider whether plaintiff established bad faith through circumstantial evidence. To meet this burden, plaintiff must establish the following 4 factors. 1. Evidence once existed that could fairly be supposed to have been material to the proof or defense of a claim at issue in the case. 2. The spoliating party engaged in an affirmative act causing the evidence to be lost. 3. The spoliating party did so while it knew or should have known of its duty to preserve the evidence. And 4. The affirmative act causing the loss cannot be credibly explained as not involving bad faith by the reason proffered by the spoliator. Here, plaintiff has established bad faith and intent to deprive. Okay, so they get into the reason as to why bad faith was present. Evidence once existed that was fairly supposed to have been material to the proof of claim. The first element is met for the reasons stated in 1B and C. Text messages and WhatsApp data once existed that could be fairly supposed to material to plaintiff's claims that defendant spread falsities about plaintiff that she knew or should have known to be false and could be indicative that the plaintiff acted at the behest of Daystar and his affiliates. In at least one case, defendant's messages with Sunstar, exactly the type of messages referenced in the preservation letter, were found in defendant's recently deleted folder and subsequently deleted. Moreover, plaintiff was able to show gaps of thousands of missing messages corresponding to conversations between defendant and Sunstar after her receipt of the preservation letter. Though the court and plaintiff do not know exactly what these messages contain due to defendant spoliation, the timing allows the court to infer that they in some manner related and were material to the issues in this case. Suspicious activity. The same can be said as to defendant's deletion of WhatsApp, the app she admitted she used to communicate with Sunstar, which was deleted from her phone before FTI's April imaging. Defendant cites to Weber v. Carnival Corp for the proposition that deleted evidence must prove to be crucial to justify the imposition of sanctions. However, Weber involved non-ESI spoliation and used a pre-Scienza standard which largely mirrored Florida's spoliation standard. While Florida law may be used to consult the court's analysis of spoliation, it is federal law in Rule 37E2 that ultimately decides the issue. Moreover, courts in this circuit have stated that Rule 37E's prejudice requirement mirrors the requirement on non-ESI spoliation cases that evidence be crucial to the moving party's claims or defenses, and sanctions under 37E2 do not require a further showing of prejudice. Rather, the finding of intent required by subdivision E2 can support not only an inference that the lost information was unfavorable to the party that intentionally destroyed it, but also an inference that the opposing party was prejudiced by the loss of information that would have favored its position. Committee notes on Rule 37E2, therefore, as indicated here, defendant's testimony and pattern of deletions indicate bad faith spoliation, inherently prejudicing plaintiff. Defendant engaged in an affirmative act causing evidence to be lost. Next, defendant does not convincingly argue that these deletions happened by accident or by some way other than defendant herself. She has no real explanation outside of she deleted them. While defendant attempted to lay foundation that the deletions could occur through errors transferring data from one phone to another, this argument is contrary to defendant's own deposition testimony, where she admitted that she deleted messages from her phone and that she had no reason to doubt FTI's report showing thousands of deleted messages. So she was contradicting herself even in the deposition. All right. And again, while defendant claims she did not delete messages relating to plaintiff, she had no explanations for why she deleted messages from Sunstar, despite being under a duty to preserve those exact messages. Her contention that she preserved messages related to plaintiff that she felt were important is equally unconvincing. C. Defendant engaged in the affirmative act when she knew of her duty to preserve the evidence. Okay. As explained in 1A, defendant undoubtedly had a duty to preserve evidence related to this case and was explicitly notified of such duty on October 29th when she received the preservation letter. The preservation letter specifically outlined that she was to retain any and all communications with or regarding Daystar and Sunstar. Despite this knowledge and notice, she deleted messages, including those directly with Sunstar. Similarly, she deleted WhatsApp multiple times during this litigation period, which she used to communicate with Sunstar. D. The affirmative act cannot be credibly explained as not involving bad faith. Lastly, defendant had no explanation during her deposition, nor did her counsel during the hearing for these deletions. Rather, when asked about the November text, defendant simply responded that she did not know why they were deleted. Who else got access to your phone? She provided no other explanation. And while she stated that she did not delete messages from Sunstar, she simultaneously did not know how or why Sunstar's texts were in her recently deleted folder. Defendant's lack of a credible explanation for her actions gives the court no other avenue than to infer that the deletions were made purposefully and knowingly. You going out so sad. For what? Ultimately, the undersigned finds that defendant acted with intent to deprive when she chose to delete the relevant messages and data. Here, like in other similar cases, defendant had both the motive and opportunity to either preserve and collect her message data or delete it. Defendant chose the latter. Indeed, how crucial these messages are is something only defendant will ever know, which is precisely the issue. Which also means plaintiff Megan Thee Stallion was prejudiced in not having the information needed. As a result of plaintiff's intentional spoliation of relevant evidence, this is referring to another case, it would be impossible for the court to ensure that the most relevant facts were being presented and for defendant to be sure why they were presenting the strongest defense. Therefore, sanctions are warranted. Now, let's get into the sanctions. As discussed above, there are two types of sanctions available under Rule 37E. First, under Rule 37E1, the adverse party has suffered prejudice from the spoliation of evidence. The court may order whatever sanctions are necessary to cure the prejudice. Second, under Rule 37E2, if the court finds the party acted with the intent to deprive, which they basically have already outlined, the court may order more severe sanctions, including an instruction to the jury that it may or must presume the information was unfavorable to the party. Here, plaintiff seeks an adverse inference. Okay. Now, the adverse inference here. For the reasons stated above, the court finds that an adverse inference is appropriate to cure the spoliation of messages and data from defendant's phone. There are different types of adverse inferences, each within increasing levels of harshness based on the nature of the spoliation. The harshest type of inference instructs the jury that certain facts are deemed admitted and must be accepted as true. A second type results in the imposition of a mandatory but rebuttable presumption. The least harsh adverse inference allows the jury to presume that the lost evidence is relevant and favorable to the innocent party. This latter type of adverse inference also allows the jury to consider the spoliating party's rebuttal inference and gives the choice of whether to draw an adverse inference. Here, plaintiff requests an unrebuttable adverse inference as follows. This is Megan's request. A party to a lawsuit such as the defendant has a legal duty to retain and preserve paper and electronic messages and other documents that concern the case. This includes, among other things, all electronically stored information in one's possession, custody, or control, such as email, text messages, and other communications stored on applications on one's phone, computer, or in the cloud. The day before plaintiff filed this lawsuit, her attorneys formally notified defendant that plaintiff was going to file the case and that she had these retention and preservation duties. Despite this written notice and these underlying legal duties, defendant deleted several thousand text messages, emails, and chats from her phone and her WhatsApp and Discord accounts. In reaching your verdict, you should assume and infer that the documents that defendant deleted would have shown that her statements about plaintiff that are at issue in this case were false, and that defendant either knew them to be false when she made them or had serious doubts about whether they were true when she made them. As explained in detail above, the undersigned notes the severity and seriousness of the spoliation that has taken place here and defendant's lack of cogent explanation for the same. However, plaintiff's proposed adverse inference requires the court to assume facts that have not been proffered by the evidence, namely that the spoliated messages would have explicitly shown defendant's statements were false and defendant knew or should have known them to be false. Rather, the undersigned finds that the following adverse inference is appropriate based on the evidence of the hearing. A party to a lawsuit such as the defendant has a legal duty to retain and preserve paper and electronic communication, other documents that concern the case. Blah, blah, blah. The day before, filed the lawsuit. She knew she had to preserve. Despite this written notice, she deleted. In reaching your verdict, you should assume and infer that the defendant intended to deprive plaintiff of the evidence in the deleted messages and chats, that at least some of the deleted messages related to the claims in this case and were about plaintiff, and that these deleted messages were unfavorable to defendant. All right? So the judge basically corrected what was submitted. The above adverse inference is based on the information provided during the evidentiary hearing regarding the nature of the deleted evidence, namely, the undersigned may infer that the deleted messages were related to plaintiff and the claims. As the court continues to receive information before and during trial, including more evidence of what may have been contained in the deleted messages, the district judge may choose to alter or amend the above instruction at her discretion. Thus, while the undersigned finds that these adverse inferences to be an appropriate sanction based on the present record, they are subject to the trial court's discretion and the trial court's determination. B. Monetary sanctions. In addition to the adverse inference, the undersigned finds that monetary sanctions are also warranted. Defendant shall pay plaintiff the reasonable amount of fees and costs incurred to bring the spoliation issue to the court's attention, including the costs incurred as a result of the evidentiary hearing. Okay? So, Milagro will have to pay Megan Thee Stallion a reasonable amount of fees to bring this spoliation issue to the court's attention, including the costs incurred as a result of the evidentiary hearing. So that's going to be some legal fees and different things. And we don't know how much Megan's legal team is charging. This shit ain't cheap, though. Defendant's notice of hearing. Lastly, the undersigned must address the objections defendant raised before and during the hearing regarding notice. As stated before, the parties have been aware of the potential for spoliation proceedings since at least plaintiff's July 11th, 2025 notice of discovery issues and the July 14th discovery hearing. On Tuesday, July 29th, plaintiff emailed the court renewing her request for spoliation sanctions, citing new discovery pointing to blatant and rampant spoliation. Plaintiff's counsel indicated they had conferred with defendant's counsel that morning on the issue and was planning on continuing conferral efforts on the morning of July 31st. Defendant's counsel emailed the court that same night, July 29th, informing the undersigned that she would not be available for a hearing until at least August 6th. On Thursday, July 31st, plaintiff emailed the court detailing new evidence of purported spoliation and again renewing the request for spoliation sanctions. This included new information found from FTI's analysis of defendant's backup hard drive and defendant's testimony from her deposition. Plaintiff's counsel also stated that no meaningful conferral had yet occurred as both of defendant's attorneys had been unavailable and did not understand the rush in meeting and conferring. Plaintiff also attached an email thread to the July 31st correspondence detailing messages between the parties and FTI extending back to May 5th, 2025. From this attached thread, it appears that FTI updated the parties on July 25th of their findings from the review of the backup drive. Thereafter, on July 28th, plaintiff's counsel reached out to defendant's counsel indicating the intent to renew the spoliation request and asking to meet and confer multiple times. Defendant's counsel reiterated they were unavailable and did not see the need for an expedited hearing on the matter. So Milagro's legal haven't really been handling their business either. On Friday, August 1st, the court informed parties by email that it would hear the spoliation issues during an in-person hearing on August 6th or 7th and requested counsel's preference based on their availability. On Monday, August 4th, the court informed the parties that it had set an in-person evidentiary hearing for August 7th at 9:30 a.m. On August 5th, the court apprised the parties that it had set 2 hours for the hearing. On August 6th, the day before the hearing, defense counsel forwarded the court an email thread between the parties detailing a meet and confer call that purportedly took place on either August 4th or 5th and requesting the evidentiary hearing be moved based on a purported stipulated extension of fact discovery. Plaintiff objected. The court reminded the parties that plaintiff had renewed its request for an evidentiary hearing more than a week prior on July 29th and that defense counsel had previously represented to the court in her July 29th email that she would be available for an evidentiary hearing after August 6th. Therefore, considering impending case deadlines, the hearing would proceed as set. With respect to defendant's expert witness, defense counsel later at 5:12 p.m. on August 6th forwarded an email thread indicating that defendant's expert would be unable to testify in person at the hearing the next day. Notably, the defendant did not proffer their expert's opinion on the missing text messages at the evidentiary hearing and have yet to make a proffer. Moreover, the discovery, not fact discovery as a whole. Defense counsel referenced this email during the hearing and stated that they had requested defendant's expert to appear via Zoom, but did not hear back from the court. Putting aside the fact that defense counsel did not apprise the court of their expert's unavailability until the evening before the hearing, the court notes that counsel did not actually make a request in the email for the expert to appear via Zoom. Indeed, the email thread forwarded to the court shows that defendant's expert informed defense counsel on August 6th at 2:02 p.m. that he would be unavailable to attend the hearing in person, but would be able to attend via Zoom. The expert requested that counsel ask the court if he would be able to appear via Zoom. Counsel forwarded this thread to the court, but in the message to the court simply stated, "Unfortunately, our expert witness isn't available. As I said, I did not contemplate a full-blown production with 10 people and expert witnesses presenting when I said I could be available on the 6th or 7th. It was not presented as a 2-hour hearing at most. I expect them to present a report. This is unduly prejudicial. I will make sure to note my objections on the record. Nowhere in the message to the court does counsel actually request for the expert to appear via Zoom. The court will not infer a request where none is explicitly made. Moreover, counsel stated during the hearing that she was told that nothing could be done via Zoom. It is unclear where counsel received this information from, but that is not correct, and such requests are considered by the court on a case-by-case basis." So even your legal team is lying. Damn. Something's missing here. The fact that the text messages were missing was fully explored at defendant's July deposition, and that the messages are in fact missing is not in dispute. Conclusion. For the foregoing reasons, plaintiff's request for spoliation sanctions is granted as follows. Plaintiff is entitled to submit the following jury instruction at trial pending any alteration or amendment the district court judge deems necessary. So a party to a lawsuit such as the defendant has a legal duty to retain and preserve paper and electronic communications and other documents that concern the case. This includes, among other things, all electronically stored information in one's possession, custody, or control, such as email, text, and other communication stored on applications on one's phone, computer, or in the cloud. The day before plaintiff filed this suit, her attorneys formally notified defendant that plaintiff was going to file the case and that she had these retention and preservation duties. Despite this written notice and these underlying legal duties, defendant deleted thousands of text messages and removed the WhatsApp app from her phone that potentially contained messages and chats. In reaching your verdict, you should assume and infer that defendant intended to deprive plaintiff of the evidence in the deleted messages, that at least some of the deleted messages related to the claims in this case and were about plaintiff, that these deleted messages were unfavorable to defendant. So as of now, unless the district court at trial decides to change this, this statement will be presented to the jurors. So they will come in knowing that she deleted thousands of texts, deleted WhatsApp, which could have potentially contained messages and chats regarding Megan Thee Stallion, that she was in contact with Tory Lanez and his father, and it was on her to preserve those communications, which she did not. And they say in reaching your verdict, you should assume that the deprivation of this evidence was at least at some point unfavorable to Milagro. So they're going to come in knowing she's a fucking clown. And it won't be, a threat to the jury pool. They're just going to know off rip she's a fucking clown because of her own behavior and the sanctions imposed in court. The parties shall meet and confer within 5 days of entry of this order as to a reasonable amount of fees and costs that plaintiff incurred by having to bring the spoliation issue to the court's attention, including costs incurred as a result of the evidentiary hearing. If the parties cannot agree, then within 10 days of entry on this order, plaintiff shall bring the matter to the undersigned's attention by contacting Chambers to provide the undersigned with the amount requested, along with time entries establishing the amount. Defendant shall then have 5 days thereafter to respond. Milagro must pay. Now, at this time, we don't know exactly how much, but I would assume whatever the amount is, she probably doesn't have it on hand. So this is only going to be carried over. And I'm assuming that she's finna lose terribly next month. So I can only imagine what the final total is going to be that she ends up owing Megan Thee Stallion. All for what? Losing all credibility, taking up for a nigga that shot her, and getting a few $1,000s here and there as an allowance from some old joker. Disappointing. Not that I knew or cared much about her, but still disappointing nonetheless. Now that we've reached the ending of this filing, let me know what y'all think of all this down below. You know what I'm saying? Not only have the sanctions been granted, but also a redeposition for the DJ That Don't Spin, aka Academics, was granted. We'll see what that entailed once they actually release the deposition, because remember, the first deposition took place via Zoom. This one actually took place in a courtroom in front of a judge. So we don't have that information just yet. Also, the DJ That Don't Spin claims that Rock Nation has people, has private investigators showing up at his house and at his associates' cribs, and basically saying that private investigators are spying on him and his friends. Come on, man. Come on. You got Aiden Ross going on stream. He's kirking out, talking about people are watching him and he's in court and he wants to leave the U.S. Who told you to stay? You the one that was interviewing Mr. Orange Man. Clearly you love the U.S. You don't love it no more? You want to leave? Who's stopping you? And On October 16th, I believe it is, Tory Lanez will be subject to a hearing to see whether or not he can proceed with a protective order that would quash Megan Thee Stallion's motion for an additional deposition because he was so disrespectful in his first that they would need to conduct another one in front of a judge. All right. So everyone that has been the opposition up until this point, they've been taking L's. They've been having to pay sanctions, fees, legal fees. And I don't think any of this is going to stop. But I will give you updates when I have more information, all right? Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I'll catch y'all on the next one, man. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'll never politic and the drama be piling on. Father and greats unacknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stacks I built. I had to evolve and grow, cause I could've